We're live.
Good morning. It's May 26th in Senate Judiciary. We are catching up on H772. There was some major changes made in Senate Economic Development, and we're going to get a walkthrough on a general overview on what those changes were. And we have led counsel here to provide us that walkthrough.
Good morning. For the record, Cameron Wood, Office of Legislative Counsel. I'm going to share my screen and I'm going to walk through two documents with you. I may have to kind of swap back and forth. The first thing the main document I'm going to be walking through are the proposal of amendment from the Senate Economic Development Committee. So you have your report for H772, which was a strike all, where you made certain changes throughout what the House sent over. And then the Senate Economic Development Committee is proposing to make amendments to your report that came out of this committee. So it's listed here as instances of amendment. It's not listed as a strike all. So I'll kind of walk through what each of these instances would do. There, before I go through kind of individually each of them, I will say globally, what they're proposing to do is take everything out of the bill other than the no trespass changes and the court administrator report regarding a dedicated residential rental housing docket. Those two remain. Everything else they're proposing to strip out. So what you see here in the first instance of amendment is in section 1, striking section 1 in its entirety and inserting on line 10, section 1 deleted. So what does that include? So I'm flipping over to, this is your report of 772. I'm just going to quickly mention this is taking out the limitation on rent increases. There was language in there about landlord could not increase rent more than once in a 12-month period. There was
Before you leave that, it says, shall not prohibit a landlord from increasing rent after the purchase of a dwelling unit, subject to the requirement. I am wondering, so that unit that they purchased, they could have had the rent increased 2 months. Somebody else purchased it, they're allowed to increase the rent.
that was how it was structured. Yes, sir. To authorize that, but they're proposing to remove this.
Yes.
Yeah, got it. But yes, sir, that's how that it came over from the House.
Okay, thank you.
There were changes in here regarding residential rental applications, adding the definition of an application fee. And then if you recall, there were sections here about authorizing a landlord to charge for a credit or a background check if they could only charge costs for the credit or of a credit check or background check. And then there was a section here on security deposits, limiting how much a landlord could charge for a security deposit. There was, in addition in here, some posting you added in, or you requested adding in specific language to ensure that for municipalities that had a 1-month security deposit, that could still, move forward and wouldn't be struck down based on the change here. There were some amendments to retaliatory conduct prohibitions. There were 2 sections being added in where a landlord could not retaliate against a tenant if the tenant takes any legal action authorized by law against the landlord or has contacted law enforcement to respond to an instance of domestic abuse. That section would be removed. And then you get to the termination of tenancy section 4467. And here's where you had in subdivision 3 that the landlord cannot terminate the rental agreement for the individual who is seeking or is the subject of a medical assistance for a drug overdose. That would be removed. And then you had sub 4A and B about the landlord not being able to terminate the rental agreement for the individual who's the victim of domestic abuse, sexual assault, or stalking. That would be removed as well. And so then the second instance of amendments is to strike out section 1A in its entirety and insert in either of the deleted there on line 13. 1A was the bifurcation section. Where you all recall, this is where the victim tenant would be able to request in writing to bifurcate the rental agreement if they were the victim of domestic abuse, sexual assault, or stalking. And if that request had a court order requiring the perpetrator to vacate the premises, then the landlord was obligated to bifurcate the agreement in that instance. That section is being proposed to be struck in its entirety as well. So then we get to the ejectment section, which would be section 3. And similar to the other two, you look at the third instance of amendment here on line 14. They're proposing to strike that section in its entirety as well. And what that meant coming out of this committee was there were 2 amendments here. The first was a technical amendment in section 4853 to just remove a subdivision A. And then there was this section 4854, which made changes to how long the landlord was obligated to maintain the property of an individual after receiving the writ of possession. And this would alter the timeline to when the landlord becomes immediately restored to possession, then they could dispose of the individual's property that remained in your report. They're proposing to strike all of that. So then you get to the trespass sections. And here's where, if you remember, there was a purpose statement here about what is the purpose of the changes in section 5. And then you had a section 5 that has, if any of these 4 conditions are met, then the landlord could issue the no trespass order against a tenant's guests. If the tenant consented under A, if the invitee or licensee, so if the guest, this is in sub B, if the guest violated the terms of the dwelling unit's lease agreement, under sub C, if the guest violated state or federal law while on the premise. And then you added in this subsection D, if you all recall, that if the guest has previously been ejected from the dwelling unit under 9 BSA 4467B. So that would be under B, if you remember, there's a B1 and a B2. B1 is the tenant is violating material terms of the lease agreement or not complying with their obligations. And then B2 was the criminal activity, illegal drug activity, or acts of violence. Those are 2 subdivisions that exist under 4467B, where you can terminate the rental agreement. The Senate Economic Development Committee is proposing to make 2 changes to what you all passed in this trespass section. I'm going to pause.
Yeah.
Wondering about, under our state law, you can use cannabis in your own domicile, including a rented apartment. But that, yeah, great. So that if somebody smoked in their apartment, the landlord could evict them.
So like this isn't about eviction. This is just about no trespass.
Or no trespass. Yes.
But you already have in federally subsidized housing, you already have those landlords are required to have in their lease provisions around, not using illegal substances on the property.
Yeah,
There already is an issue there, conflict state and federal law. But to your question here, this is about issuing the no trespass. And so if someone was, if you have a scenario where a guest is using cannabis in someone else's apartment, could a landlord issue a no trespass and say that you violated federal law while you're on the premise? Conceivably, yes, I think that is possible. I think, you may get into a situation where the tenant is arguing that, it's authorized by state law. And so,
right, but we're explicitly saying, well, so, thank you.
Yes, but if you have a no smoking policy, it's smoke doesn't matter if there's a conflict.
Then you're right. Probably follow the other.
right. So the 2 changes that the Senate Economic Development Committee is proposing to this language here is first in B, whereas the guest is violating the terms of the dwelling unit's lease agreement. They're proposing to add in that it has to be a pattern of violating the term, so it wouldn't be just one instance. So you can see that here in the 4th instance of amendment here, where they are proposing to strike that subsection B insert this new subsection B. So it would be there on lines 20 and 21, towards the end of line 20, beginning of 21. The yes, subject to the order is engaged in a pattern of violating the terms of the dwelling unit's lease agreement. And then when you get to the sixth instance of amendment here, beginning on lines 3, operative language on line 6, they add a definition. Pattern of violating means 2 or more acts over a period of time, however short. So it would just have to be 2 instances as opposed to 1 instance is their proposal. And the other change that they're proposing is this 5th instance of amendment here on lines 1 and 2, where, pardon me, I'll switch back to the other document. This language in subdivision D, where you've added in that a landlord can issue the no trespass order to an individual who has previously been ejected from a dwelling unit on the property. And remember, there was a lot of discussion about, well, should it be for any ejectment or should it only be for a subset of ejectments? And that's where you landed on limiting it to you've been ejected previously from the premises due to a termination under 4467B. Their committee is proposing to further limit it and to say only for ejectments under B2, not just B.
And B2 is criminal activity.
Yes, sir. B2 was criminal activity, illegal drug activity, or acts of violence. But what does that mean? That means if you limit it to B2, any ejectment under B1 you would not be able to issue that no trespass order automatically. B1 would be violating the material terms of the lease agreement or not complying with your obligations under the chapter, which could be kind of disruptive behavior to other tenants or damage to the dwelling unit. Those are probably the 2 primary things that we would give a termination for that section.
Okay, so can you scroll up just a little bit?
Yes, sir.
With the next page. Okay. So
You go.
with 16 and 7, line 16 and 17, in terms of the lease agreement, if I'm trying to reconcile the 2 differences here between being ejected for criminal activity versus violating the terms of the lease agreement. So I guess my question is, if somebody has a pattern of violating the lease agreement and it's not criminal activity, and they're not a tenant, they're a guest, and that person be trespassed under the new changes proposed by economic development.
Yes, if they're violating the lease terms, the issue you would run into is it's a question of timing. You know, my understanding is one of the goals that was trying to be accomplished with this language was twofold. If somebody is on the property, you know, continuing or violating the term once, or, you know, violating state or federal law, to be able to issue a no trespass in that instance. But separate from that, if you have to eject someone, then the landlord wanted to be able to issue the no trespass order at that time, so they don't have to wait for the person to come back and then continue to violate the lease terms or continue to engage in illegal activity. And so under B, conceptually, the individual has to be a guest, be on the property, violate the terms while on the property before the landlord can issue the no trespass order.
And then
Whereas
the distinction with the second one, I think I'm getting it now, is that with the second one, it has to be somebody who is a former tenant and ejected, because they could only be trespassed if it's criminal.
under the change that the economic development committee is proposing, yes, sir.
Okay. Yeah. Thank you.
Yes, sir. Okay. So going back to their amendment, so that gets us through the 6th instance of amendment. As I mentioned, the 6th was just adding in that definition of pattern of violating. The 7th instance of amendment is just strike section 7, 8, and 9.
Yeah, before you go further, committee, how are we feeling about the changes regarding the trespass section?
Just a real quick thing on the end of what just Andy mentioned, how it pertains to a past tenant and how it pertains to just the guest. How do those differ if the past tenant isn't a guest?
Yeah, so
Are they treated differently because they used to be a tenant?
no.
Okay.
Not treated differently. What the subdivision D was intended to authorize was if you have an individual who you have to eject from the property. I, as the landlord, I don't have to wait for you to come back as somebody's guest.
Mhm.
Continue to violate the terms of the lease agreement or continue to engage in criminal activities before I'm able to issue that no trespass
Oh,
order.
okay.
So what D would allow is if you have been ejected from a dwelling unit, I can go ahead and issue that no trespass order at that point and not have to wait for you to come back and continue to engage in whatever activity. Back to your question, you were asking your committee how they felt about this.
So how we feel about damage, which in my opinion was exclusively the realm of the judiciary, but Jason had made changes on this. So.
I didn't realize we sent over such a bad bill, but now after redoing it, I don't like the changes.
For the no trespass,
No trespass section.
yeah. Would you propose? Do you prefer reverting back to the Senate Judiciary language for the no trespass section?
Well, I think this offers only one side too much protection here, not the other side. I'd have to review what the original version was. And I apologize for being late. Yeah, about this, but I'd have to have a side by side on them, I guess.
I think the main difference, and please correct me if I'm wrong, the main difference being that they added the pattern of conduct or the pattern of violating over a period of time in terms of the lease agreement. And then the other part for somebody who was previously a tenant and is now a guest and then they trespass. Yes, sir. I'd say the two changes there in the sub B, it's the pattern. Instead of having one instance of violating lease terms, it would have to be a pattern. And then for the subsection D, if you're going to issue the no trespass against somebody who you had to eject, they're proposing to limit it to only ejectments due to criminal activity, illegal drug activity, or acts of violence. So if you had to eject somebody because they were violating the terms of the lease agreement under B1, you wouldn't be able to automatically issue that no trespass. So that person would be able to come on the property as a guest. And then if the person continued to engage in a pattern of violating the lease or violate state or federal law, then you can issue the no trespass at that point.
I think that's similar to what I like about the one with the ongoing threat versus a threat. I think that mirrors that as far as an ongoing pattern. So
Or the different.
So would your preference be not having the language on line 6 through 8 that say pattern of violation? Is that?
Yes. Yeah.
And then I just took out the rental credit reporting that is very company.
Yeah, I was gonna get to that on the second instance. Yep. Okay.
Yeah.
Okay, so then to the seventh instance of amendment here, deleting sections 7, 8, and 9. Section 7 was the credit reporting pilot program. Section 8 was language around security deposits, a transition period for the changes that you made above, capping how much a landlord can charge for security deposits. And then section 9 was a program through CVOEO to training for landlords and tenants. Section 7 and Section 9 had an appropriation as they came out of the House General Committee. And then the House added in the language that you've seen and saying that the duty to implement this section is contingent upon an appropriation. Well, neither one of those programs had an appropriation at this point in your budget negotiation, so I recommended to the committee to remove them so there's no ambiguity for the public. And then Section 8 was no longer necessary because if you delete Section 1 in its entirety, you don't need that Section 8.
And I'm sorry to interrupt. Can you just give us the brief overview on section 11?
Yes.
Then I'm gonna ask the committee about the potential amendment.
So Section 11 is striking the report, and what they did primarily is this is your version of the report. There's a lot of language up here in sub A, which they kept, that committee kept, about the cost of implementing dedicated docket, workforce impacts of a dedicated docket, Whether there's facilities to be able to accomplish having a dedicated docket. There was then this language in subsection B that you included, which was legal issues to consider, and so this is just starting at the top here, legal issues to consider in requiring the expedited hearing, how the court would determine that a tenant is an ongoing threat, whether there are procedural issues with the 21-day timeline, how the court would determine damage to a dwelling unit is a threat to the health or safety of others, and then whether there are issues with shortening the timeframes. The judiciary, the court administrator, and Judge Zone came into that committee and testified that they were not comfortable with a lot of the language in subsection B because it was asking them to opine on legal matters that may come before the court. And so they just had concerns with that and they requested to strike subsection B in its entirety. The committee did keep a version of this language about are there procedural issues of when to begin calculating the 21-day time frame. Should it be with the filing of the complaint or should it be with the service of the answer? Because if you begin 21 days from the filing of the complaint, technically the answer and then has 21 days to file the answer. So if there were issues with that, so that was kept.
Cam, unfortunately, we're gonna have to stop. I'll say I'm fine with the changes to the study because we didn't have the time to take testimony for the judiciary and I thought that they provided plenty of information to economic development about the proposed changes there. The bigger question is going to be returning at least part of the bill back to the language that we passed out of here unanimously, which had the Samaritan language and the bifurcation for the domestic violence piece. And then also the question of, do we keep or remove their addition to the no trespass piece, which is the pattern of violating. Personally, I need to think a bit more about the pattern of violating language, but how do folks feel about an amendment for tomorrow, which would return the bill mostly back to what we already passed out?
Supported what we passed out here, so I would certainly support that.
Real quick, what was the good Samaritan piece? Real quick.
It's the landlord couldn't terminate an individual's rental agreement if the individual was seeking medical assistance due to somebody having an overdose in the apartment, or if the tenant was the subject of an overdose and somebody called and got medical assistance. So you couldn't terminate under those circumstances.
So my question on that, depending on what the overdose on is, that not considered criminal activity if you overdose on illicit drugs?
So the language was there specifically to say that you wouldn't be able to terminate the rental agreement under those circumstances under that section. So even if it was criminal activity, you wouldn't be able to terminate based on the person getting the medical assistance for the drug overdose.
I guess I'm with the clarification portion of it, but not so much the disability portion of it as far as criminal activity taking place on the premises, but if they call for help, which they should, obviously, but still illegal activity.
Overdosing in and of itself isn't a crime, but what's, since we passed it versus now, what's caused your opinion to change on it?
Well, just thinking about overdosing itself is not a crime, no. But being in possession of illicit drugs and then overdosing, criminal activity, where I believe we struck out illicit drugs activity as far as the original one that came out of here. It's still criminal activity.
No, sir, you kept that would still remain, and that
So we kept it in
second B2 would be criminal activity or illegal drug activity.
So we got that, but this is going to override that. I'm thinking about this.
What would override? What you? Well,
There's criminal activity in there, but yeah, if you OD on illicit drugs, okay, so because you OD called for help, all of a sudden the criminal activity is gone now because of the Good Samaritan laws. Is that what you're proposing?
I think you're talking about the no trespass. It's separate from the Good Samaritan piece.
They said that the illicit activity was still in there.
So
Criminal activity slash.
you can terminate the rental agreement due to the tenant engaging in criminal activity or illegal drug activity. Those two are in B2. Right? What this language was being inserted to say, but you cannot terminate the rental agreement due to somebody seeking medical assistance for the drug overdose. And Senator, I think what you're saying is you want to get medical assistance to somebody who's having a drug overdose, but is it still criminal activity that should allow a landlord to terminate the rental agreement? And I think I'm trying to pull up 18 VSA 4254 because I believe, and we're getting outside of my area of expertise, but I believe you have created immunity from criminal prosecution for individuals who seek medical assistance due to a drug overdose, but the depth of that section, I would need to defer to my judiciary colleagues because they're like, to this.
Well, let's contemplate that, and then we have to get to the floor now.
I mean, those good Sam Cruz things around like arresting someone for that